Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. What's up, everybody? We're back in it today, talking about Elon Musk and Twitter. And this insane, in case you didn't like the title, Ludicrous was a play on words for Tesla. Insane mode. That is the timeline of this trial. And it is so interesting to me, and so many things are happening that as the trial and as the case and the litigation continues, I'm going to continue to point out just how crazy this timeline is. Things happened this weekend that are insane and seemingly impossible to fit into this timeline. Elon Musk filed his answer and counterclaims. We know there are counterclaims, even though they were filed under seal. So a lot of stuff is happening in this case. But today I wanted to actually go through the scheduling order entered by the judge. And this happens in a lot of cases. It happens in just about every one of our cases. After we mediate it and can't settle it, the judge says, here's when discovery cuts off. Here's when your witness list cuts off. Here's when your trial date is. Here's when your pretrial date is. Here's when your motions are due. And I'll explain to you what that means by going through an actual trial order here in this Twitter v. Musk case. If you're interested in this case, make sure you let me know by liking the video and commenting any questions you have below. A lot of people tagged me in one of the posts on Twitter that I'm going to share today to show what some of this discovery is like and how broad it is and how much time, to me, it feels like it would take to answer these questions. And we'll talk about what all that looks like, what discovery would be like in this case as we go through it. But you can find me on Twitter and Instagram at Tragos Law to send me that stuff. So let's get into it here. Let's take a look at this scheduling order. All right. Order governing case schedule. Whereas on July 12th, plaintiff filed its complaint. Court granted plaintiff's motion to expedite the proceedings on July 19th, and here is the order. This is what has to happen, and this is the date it has to happen by. So by July 29th, which has already happened, defendant Elon Musk has to answer the complaint, file counterclaims, which he's done. Plaintiff can answer the counterclaims by August 4th. I haven't seen if they've done that yet. Sometimes they can just summarily deny everything. Deadline for serving initial requests for productions is July 29th. Of documents and initial interrogatories, the parties shall use best efforts to be complete in their initial requests. Later requests will be permitted for good cause only, meaning, and in most cases, as you see when we're going through all of these unsealed documents in the Depp v. Heard case, there are 1st, 2nd, 3rd, 4th, 5th, 11th, 12th, 17th sets of interrogatories and requests for production. In normal cases, you ask so many different sets of interrogatories, so many different sets of requests for production. In this case, the judge is saying, do your best to get all the questions in on your first shot, which would actually be amazing in every case, because now sometimes there's stuff you don't know that you do have to follow up with, or you find out in deposition. A lot of times after depositions of the clients or the corporate reps or employees, we have to do another set of discovery because there's a lot of things we didn't find out. And we talk about, or that we found out in the depo that we didn't have. And a lot of times, I'm not going to say it's anybody's fault, but that's the only way to discover that this stuff even exists, to know to ask for it. So sometimes it is necessary to follow up with more sets of questions. And if there are depositions in this case, I'm sure that will be considered a good cause for additional sets of questions. Deadlines for serving initial discovery requests on third parties was August 1st. And that's important because that's something we are going to talk about right now. Let me pop this off the screen and share this thread here I was tagged in on Twitter. Lots and lots to dig through in these subpoenas. Some obvious, some random, some weird, some boring. So here's one of the questions. This is just an example of a request for production question that was sent to a third party. Actually a subpoena sent to a third party. All documents and communications relating to the effects or potential effects of changes in the price of Tesla Inc. common stock on the merger, debt financing, the equity financing, financing commitments, and or defendants' intentions with respect to closing and or efforts to close the merger. And here's everywhere he sent it, or they sent it. Bank of America, Citibank, BNP Paribas, et cetera, et cetera, et cetera, Barclays, et cetera. All these financial institutions. And then here are more, Morgan Stanley, et cetera, and more, and more. These right here, what we're looking on, can't stop, won't stop, new additions, all of these places. Are there any banks left? Literally, they are sending these types of subpoenas and discovery questions to all of these financial institutions. That falls under the blanket. If I can bring back up the scheduling order, that all falls under C. And those subpoenas and those requests for initial discovery to third parties were filed Saturday night, Sunday morning. So right before August 1st, which was yesterday, Monday. So at the last minute here, which everything's going to be done at the last minute because of this abbreviated schedule. So don't think anybody's being lazy or waiting or sitting on anything. This is so incredibly abbreviated that everything's going to be done basically on deadline day, which is when this was. And they're working weekends and nights all day, every day. Twitter's lawyers and Elon Musk's lawyers will be working on this case until October. You can almost guarantee that. A third party, we've talked about this before. If you're sending requests to third parties, that means somebody that's not a party to the case. So not Elon Musk, not Twitter, none of the other companies that were listed in the complaint. Those are the parties. If you're not one of those corporations, companies, or people, then you are a third party. So all of these banks are third parties. So there are two different ways that these subpoenas can be blocked. Elon Musk or the defendants can object to them, file a motion for a protective order, try to get the judge not to allow Twitter to get these documents. Or number two, the companies themselves can object. They all have lawyers. You don't think Citibank and Morgan Stanley and Bank of America, they have teams of lawyers. So if what they're asking for is protected or privileged, or there's privacy rights, or there's issues with it, or there's work product, or there's some kind of information that's private that they can't share with Twitter or can't make public, they'll either file it under seal, which Elon Musk did for his answer and counterclaims, but they'll file it under seal. They'll ask the judge for some clarification, or they'll just try to block it and object to it, which again, we saw in other cases like the Kyle Rittenhouse case, some places did that. In the Depp v. Heard case, some places did that. So these individual third parties can object on their own. So there's two hurdles that Twitter has to get through before they can even get these documents. So you have 30 days to answer. You can object. Twitter's got to file a motion. The hearing will be expedited, so they'll get kind of special treatment on getting hearings, not like normally on my cases, like any general case. You got to wait 2 months to get a hearing sometimes, which can just cause these huge delays in discovery, which is why we talked about why this is such a ludicrous timeline. And what happens? Twitter's got to make a decision, because if one of these financial institutions objects and they don't want to give these documents for whatever reason, but all the other ones answer, does Twitter say, we have enough, let's continue, let's go to trial? Or do they say, we need this answer from them, judge? And is the judge really going to force Bank of America to answer broad discovery? If they do, great. How far will Bank of America fight it? And if there is a big fight, is it going to cause a delay in the trial? Because any number of things could cause a delay in this trial. So Twitter has to be strategic in what they do. And if they decide to go to trial without these documents, they're waiving that issue for appeal. Because the judge may offer them a concession, say, do you want to wait for them to produce these documents? We'll have to kick out the trial. That's up to you. But you can't have it both ways. You can't have your cake and eat it too, meaning that's an appellate issue and we want to get to trial ASAP. You can't create your own appellate issues, like we said. Deadline to serve final request for productions and documents and final interrogatories permitted for good cause only is August 12th. It's like you won't even have your answers. Now, I don't know. This could be my ignorance because I've never handled a case in this jurisdiction under this specifically short timeline. I don't know if the judge is limiting the timeline of when they can answer discovery. If it's less than 30 days, maybe it's only 12 days, because they're not even going to have their answers to their first set of discovery before the deadline to file their final set of interrogatories and requests for production. Deadline for identifying opening expert witnesses and the general subject matter of their testimony. These are known as expert disclosures. August 15th is when that's due. That's just so soon. So you have to hire them. You have to pay them. They have to review the documents you want them to review, which you're supposed to be getting in discovery. Potentially you're serving on August 12th. Seems impossible, right? You're serving the discovery on August 12th. That doesn't mean it's going to be answered on August 12th. Yet you're supposed to disclose what your expert's going to testify to by August 15th. And again, it doesn't have to be perfect. As you saw again in the Depp v. Heard case, there's so much that happened in that case. That's a great illustration and learning points on how litigation goes. But you saw, they said, in your disclosures, this is what you said the expert was going to say. Is that not what you're saying now, doctor? Because those initial expert disclosures are kind of giving the lawyers an idea of what the expert's going to say to see what counter experts they need to get. But this does just say opening expert witnesses, identifying them in the general subject matter. So my guess is later in this scheduling order, there will be a more final identification and disclosure of experts. F, parties to substantially complete document discovery by August 29th. So there's got to be some abbreviated timeline for when they actually have to answer this discovery. Because if you're serving on August 12th and it's got to be all the documents complete by August 29th, that doesn't give you the normal time, 20 or 30 days. Parties to exchange privilege logs by September 5th. What are you claiming privilege on? Why? What is it? Do we need to have an in-camera review? Do we need to have a hearing on this, whether or not it's privileged? Deadline for moving to compel or moving for a protective order in connection with written discovery or document discovery. Any motion must be presented pursuant to the protocol established in paragraph 14 below. That's on September 7th when you have to file these motions. Parties to exchange opening expert reports along with all materials relied upon by the experts. Any materials relied upon by the experts previously produced to the opposing party in discovery need not be reproduced, but must be identified by Bates numbers, Bates stamp numbers. That's September 9th. So you have to disclose them on August 15th initially. Then they have to actually give them a report by September 9th. Parties shall serve initial list of trial witnesses September 12th. So again, that's a month after you serve discovery. You've got to know who your trial witnesses are. They shall use best efforts to be complete again in your initial list, but they're going to give some leeway to amend them later, which should include adverse and third-party witnesses. A party will be permitted to identify witnesses at a later time for good cause only. So it's not like we knew about them, but we weren't sure. It's like we didn't know about this person. That's why we're adding them to the list. They have to have a good reason. September 12th also, parties to complete fact discovery, including depositions, except for any fact discovery subject to a motion to compel or a motion for a protective order pending as of this date. So all their depots have to be done in the next month and 10 days. So in the next 40 days, all their fact depots have to be done unless, as I said before, in discovery, either one of the parties object and file a motion for protective order or one of the third parties object because they don't want to produce these documents or they don't want to produce somebody to testify. So all of those could still be subject to a pending motion or a pending protective order, in which case it's okay if those depots go after September 12th. It's mind-boggling. I wish I could analogize it for you guys. Like if you are a contractor and you're building a house and I say you've got to build it in a week. It's basically what it feels like. All right. Because think about all the subs and all the products and, everything that you have to actually get to build the house. It's not just like a hammer and a nail and you can go and just start building and get it done. All right. Parties identify rebuttal expert witnesses and general subject matter rebuttal testimony. That's what I talked about before. When you find out what experts they have, you got to see, do you need to have a responding expert? Deadline for moving to compel or moving for a protective order as to any fact discovery issues not subject to the deadline set forth in paragraph 1H above. Any motion must be presented pursuant to the protocol established in paragraph 14. That's on September 15th. Parties to exchange rebuttal expert reports on September 21st and any materials they rely on. Parties to identify any potential trial witnesses not previously identified. So this is kind of the end of the road here to identify your initial witness list. You'll have one other chance to finalize it, but you really have to have a problem if you didn't list somebody on this witness list is what it seems like. The parties shall work together in good faith to schedule the deposition within 7 calendar days following their identification of any trial witnesses identified pursuant to this paragraph who have not been previously deposed. Seems easy, right? Oh, it's 7 days. It's a long time to find somebody. Not if you're talking about some of these experts that may be MIT people or NASA or Wall Street people or whoever they're going to call business experts here to talk about this case. They're probably pretty busy. So to schedule their depot within 7 days is kind of crazy to think about. Parties to complete expert depositions starting September 22nd 22nd to September 29th, because again, 7 days. That's how long you have to set these depots. They got to be done. So you may not even know you have an expert until September 21st, and you got to have their depot done by September 29th. It's crazy. Parties to provide final lists of all trial witnesses by October 5th. That is the final. Plaintiff's counsel provide defense counsel with a draft of the pretrial order on October 5th. Defendant's counsel to provide plaintiff's counsel a markup of the draft, meaning they give it to them. They make their edits by October 10th. Then they file it with the court by October 10th. By October 12th is when they file the pretrial order and exhibit list. Deadlines for motion in limine, October 11th. So any evidence you don't want to come in from all the discovery and all the depositions and all the witnesses and anything that that Elon Musk is saying on Twitter that you know they're going to try to argue, motion in limine, judge, this should not come in for this reason or that. Deadline, that's on October 11th. Deadline for filing responses to motions in limine is October 12th. You have 1 day to respond to motions in limine. So if they wait until 5 p.m., you have until 12 p.m. the next day, so not even 24 hours. Less than 20 hours to respond to who the heck knows. Later on today, I'm going to look at the motions in limine in Amber Heard's case, and one of the ones that her team filed was 994 pages. So imagine if one of the sides file a 994-page motion in limine and you have 19 hours to respond. How do you even read it and digest it in 19 hours? Deadline for submitting pretrial briefs, October 13th. Pretrial conference, any motions in limine will be argued during the pretrial conference, which is on October 14th, and the trial is October 17th to the 21st. My head is spinning, and I'm usually one that wants to push it. I want to push the envelope. I want this stuff to go quickly. I hate delays, but our trial calendars are usually 12 to 18 months, sometimes longer now since COVID, since when we filed a complaint. And it always gets delayed and extended, usually by defendants. So this is insanity to me. It may not be as mind-boggling to you as it is to me. The parties may amend these dates by written agreement. So if they both agree this is impossible, they can extend that date. I can almost guarantee you they're going to extend some of these dates. They shall meet and confer promptly regarding confidentiality agreement and discovery plan to discuss privilege logs and so forth. Interrogatories shall be limited to 25 interrogatories per side. The party shall not be entitled to serve requests for admission without leave of court. So usually RFAs you can serve in cases and you don't have to ask the court. And usually you get up to 30 interrogatories. But now you only get 25 and they want you to be as complete as possible with your first shot and you're not allowed to do RFAs. And here we go. As you can tell, I'm reading this trial order for the first time with you and reacting to it because I didn't read the full motion. I like to do it and react as I'm reading with you to see what I would do if I was handed this motion as a lawyer and figuring out what am I going to do with this discovery. Well, here's your answer. The request for production and the interrogatories have to be answered 7 days after service. If you're going to object or answer or produce documents within 7 days, usually you get 30 days and it's almost never answered within those 30 days by defendants. They almost always wait, ask for an extension, make us file, send a 10-day letter, make us file a motion to compel, almost always. So the fact that they're going to do this in 7 days, where we hop back up here, and even that, serve final request for production interrogatories on August 12th, then you've got to identify the subject matter by August 15th. It's crazy. All right. Document production should commence on a rolling basis upon receipt of discovery request, meaning if you have to ask somebody else for documents and you don't have them, just keep giving them to the other side as you get them. It should not be requested or withheld in an effort to inflict unreasonable demands or extract unreasonable benefits from the opposing party. Each side shall review any discovery request served in the date with an eye toward limiting or consolidating those requests. Each side shall use best efforts to comply with its discovery obligations. I wish this is how it was in every case. I wish the judge was like, try to do your best job. Try to only ask what's necessary. Doesn't seem unreasonable for professionals and lawyers, right? But no, the only time a judge actually says something like this is when we got to try a case in 90 days, which seems crazy. Each side shall produce readily available information on or by August 4th at 5 p.m. It's like, just send what you have. If you know the other side needs it, just send what you have. And begin producing contemporaneous communications from key custodians shortly thereafter. If it's text messages you know are going to be discoverable, just send it. Because my guess is this judge is not going to like any delays on purpose. This order does not resolve any specific discovery disputes, including the propriety of any request for large data sets. The parties shall implement the protocol set forth. We need to get to paragraph 14 because that's the one they keep referencing. Prior to production, the parties shall use best efforts to deduplicate any electronic material, meaning on your own. Subject to any other objections they may have, parties shall produce for deposition or appearance at trial. So Elon Musk can't dodge depositions for 3 years, like we're seeing in some other cases around the world. The parties shall cooperate in good faith regarding arrangements for any discovery taken from parties' agents. Parties shall work together in good faith on the scheduling and location of depositions. You'd be surprised how often we fight about where the deposition is going to be taken, how close it is to our client or their client or us or them. Pretty wild, but maybe Zoom can help that in this case. Produce documents related to deposition when they're supposed to. It's basically like all the stuff you guys do in other cases that we know you do, that everybody complains about. Don't do that in this case. It's basically what he's saying to these lawyers, which I would love for a judge to say. No witnesses shall be included on either party's final witness list who were not included on at least one party's initial witness list unless there is good faith reason for including a new witness. Now, this sounds a lot worse than it is, but if something pops up that you had no way of knowing, that's considered good faith reason. You need to add them to the witness list. Parties shall work together to create a single set of trial exhibits. That's fine. Cite them in the pretrial brief. That's fine. We do that in most cases. What else do we have? Deliver additional flash drive. Each side shall designate a partner-level Delaware lawyer to review and certify their client's respective privilege log. A privilege certifier. That's interesting. I haven't seen that before. Parties shall use the following protocol for addressing discovery disputes, including document production issues. This is interesting. So let's hear what the judge really thinks, and we can use this if you ever practice in front of this judge, if you're these lawyers. This is how this judge likes to handle it. So you can say, Judge, in a normal case, I'll say, Judge, I did all this. I know this is how you like it. And they still didn't give me the discovery. Each side designate a partner-level lawyer who will be responsible for negotiating discovery issues and receiving and addressing document deficiency issues. Discovery liaisons. If this person is not the privilege certifier designated pursuant to paragraph 13, then the privilege certifier shall be automatically designated as a second discovery liaison. So it's like we're going to have other lawyer. Imagine how much just time and money are going into this case is incredible. Other lawyers that are partner level are going to look at this and be like, come on, Twitter, you know you got to turn this over. Come on, Elon, you know you got to do this. Don't make this go to the judge. The parties identifying any discovery deficiencies shall first raise that dispute in writing and send it to the discovery liaisons. So basically, there's like a magistrate. So some like lower level lawyer before it gets to the judge that's going to look at these disputes at first to try to handle them quicker. That's the point. Let's see if we can get these handled quicker. Within 24 hours of receipt of such correspondence, the discovery liaison shall, in writing, send by email to the opposing discovery liaison, acknowledge receipt of the correspondence, and either cure the deficiency or provide a reason why the production was not deficient. If a response cannot be provided within 24 hours, the discovery liaisons shall explain why and provide an estimate to when a full response will be provided. If the issue is not resolved within 72 hours, then at the election of the parties identifying the deficiencies, the parties shall submit letters to the court not exceeding 5,000 words stating their positions, attaching the relevant communications, and including a proposed order granting any relief sought. If the court requires a hearing on the discovery dispute presented pursuant to the immediately preceding paragraphs, then all discovery liaisons shall be present at the hearing. It's going to be like a full-time job for these discovery liaisons. No deadline set forth in this order shall require a filing or communication outside of ordinary business hours. If a deadline, for example, in the 24-hour period referenced in the immediately preceding paragraph falls outside the ordinary business hours, then the deadline shall be 10 a.m. on the next business day. That means 7 days to the hour. When discovery was requested ends up on a Sunday, they can wait until Monday to answer the question at 10 o'clock in the morning by Judge McCormick. Whew. Very interesting how they're going to handle these discovery disputes. But you knew, and I knew, that they were going to have to do things like this in order to get this trial done so quickly. They couldn't have the 30 days to respond. They couldn't have a good faith conference and a 10-day letter before filing a motion to compel. They couldn't file a motion to compel and wait for a hearing date in front of this judge. All these issues we knew they would have, well, the court has ways of fixing that with these discovery liaisons and these privilege certifiers, which are partner level Delaware lawyers that know the rules, that can make these calls. And you better believe if the lawyers for Twitter or the lawyers for Elon Musk disagree with the discovery liaisons or the privilege certifiers, which is probably going to happen, They better be right or the judge is not going to be happy. You still have to zealously protect and represent your client and do what's best for your client. You can't just fold, but this is just an added level of pressure. You better be right. And we know the broad discovery questions that have already been sent to third parties. It's going to get wild. Tons of documents, tons of words about to be typed and gone through by lawyers for Twitter and Elon Musk. Let me know what you think of this video. Let me know if you have any questions. If you found this timeline as insane and ludicrous as I did, please let me know because I find it incredible. So let me know what you think about this case by liking the video on the way out if you're interested in this content and want me to continue following the case. Thanks for being with us. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.